Well, good morning, everybody. Just bright and early this morning, 10 to 10. But I really wanted to crack on with the next part of this Michael Cicchini article for the Oklahoma Law Review. Thoroughly enjoyed reading through that those paragraphs yesterday. Don't know about you, but I reckon Ken Kratz ticked every single box of well, between him and Fallon, ticked every single box of things that were misconduct, prosecutorial misconduct. Anyway, let's move on, shall we, to the next section. Let's put me out of the way there. Now, so item J, we're up to page 26. Uninvited response. Prosecutors can commit misconduct in their rebuttal closing, theorizing that their improper arguments were invited by defense counsel and are therefore justified. This invited response doctrine is grossly misunderstood and frequently abused. First, in order for a prosecutor's otherwise improper argument to have any chance of finding safe haven as an invited response, defense counsel must first have made his or her own improper argument. Consider an example where, through cross-examination at trial, defense counsel established that the police never questioned an eyewitness at the crime scene. Further, counsel established that the police never tested the physical evidence that was collected from the crime scene. Then, in closing argument, counsel argued that the police conducted a shoddy investigation. The state's evidence cannot be trusted, and the evidence that was presented does not constitute proof beyond a reasonable doubt. This is a proper defense argument, and while such an argument certainly invites the prosecutor to respond by citing any trial evidence that pointed to guilt, the prosecutor may not invoke the so-called and poorly named invited response doctrine to justify making an improper argument. Continuing with the above example, assuming there was no supporting testimony at trial, the prosecutor may not argue to the jury, whether true or not, that the police did not talk to the eyewitness because he or she was afraid of the defendant and refused to cooperate. Similarly, the prosecutor may not argue that the police did not send the physical evidence for testing due to a six-month backlog at the crime lab. Such arguments invoke facts not in evidence, are improper, and were certainly not invited by defense. Counsel's proper arguments that the evidence failed to establish proof beyond a reasonable doubt. Second, even in cases where defense counsel does first make an improper argument, some jurisdictions hold that the prosecutor is not allowed to hide in the weeds, say nothing, and then launch into his or her own improper argument in rebuttal. Rather, the prosecutor may be required to object to defense counsel's improper argument and seek a curative instruction from the court. And this makes sense. Just as defense counsel's failure to object to improper argument generally waives the issue of prosecutorial misconduct on appeal, so too should the prosecutor's failure to object waive the issue of defense counsel's improper argument for purposes of invited response. Thirdly, even when the invited response doctrine does excuse a prosecutor's improper argument, the doctrine still has its limits. The prosecutor's argument must have been a necessary and reasonable response to defense counsel's improper argument. Further, prosecutor rebuttal arguments that implicate constitutional rights, such as a comment on the defendant's right to remain silent at trial, are even less likely to be justified as an invited response. Finally, even when the prosecutor makes otherwise proper arguments in rebuttal, it is important to remember that the purpose of rebuttal is to respond to arguments of opposing counsel. Just because defense counsel argued that the state did not prove guilt beyond a reasonable doubt, the prosecutor should not have license to cite matters not raised by defense counsel merely because those matters point to the defendant's guilt. If the word rebuttal could be interpreted that broadly, it would lose all meaning. Rather, the scope of rebuttal argument should be much narrower. Rebuttal shall be limited to matters raised by any adverse party in argument. Consequently, any rebuttal that goes beyond the specific arguments or facts raised by defense counsel should be considered improper sandbagging. The reactionary approach. Having identified several categories and examples of improper argument, the next question is, what does the criminal defense lawyer do about it? Following the conventional approach, most lawyers simply wait until the prosecutor commits the misconduct and then react to it. Under this approach, defense counsel must contemporaneously object to the misconduct, which then gives the trial court the first opportunity to correct potential injustice by invoking an immediate cure and forestalling future harm. Most jurisdictions follow the fundamental rule that relief will not be considered in the absence of an appropriate objection in the trial court. Unfortunately, objecting to prosecutorial misconduct, while a necessary step under the conventional approach, can be difficult and risky. And once the defense lawyer objects, the objection by itself is rarely sufficient. A, the decision to object. To begin, even if defense counsel goes into a jury trial familiar with most types of improper argument, objecting in the heat of battle is not easy. When under the stress of the situation, it is often difficult for defense counsels to quickly identify the problem and raise an objection in seconds at trial. Even if defense counsel is troubled by the prosecutor's comments, these conditions make it difficult for defense counsel to articulate their objections quickly. Even if the defense lawyer quickly identifies an improper argument and is capable of articulating the appropriate objection, this does not necessarily mean that he or she should object. Deciding whether to object during closing argument is one of the most difficult strategic decisions counsel faces during trial. Objecting can be costly. The conventional wisdom within the field of trial advocacy is that attorneys should not object during closing arguments unless things are terrible. Counsel may be concerned about irritating the judge or jury by interrupting opposing counsel, which can heighten jurors' general tendencies to favor prosecutors over defense counsel. More specifically, defense counsel may be concerned about the juror's likely reaction if her objection is overruled. A trial court decision to overrule an objection may actually encourage the jury to rely on those comments. Further, trial judges typically overrule objections, often because they do not know the law or may not even be listening to the arguments. And while it would be logical for defense counsel to think that his or her job is done when an objection is overruled, the defense lawyer may actually be on the hook for the trial judge's error. In one case, for example, even though the trial court overruled defense counsel's objection to improper argument, an appellate court summarily dismissed the defendant's appeal, holding that the issue was waived because defense counsel failed to move for a mistrial. Of course, the appellate court did not say how the trial judge could have granted a mistrial or awarded any other remedy after overruling the underlying objection. Fortunately, many jurisdictions follow the far more rational approach that if the trial court overrules the objection, no further step should be required of defense counsel because the trial court has already ruled that no misconduct has occurred. In other cases, particularly where the trial judge does not understand the law or is not listening to the arguments, the judge may refuse to sustain or overrule defense counsel's objection. Instead, he or she may simply utter a general purpose platitude, such as, "I'm not going to talk about this. I'm going to let the jury decide this case on the instructions I've given you." Similarly, the judge may utter the true but meaningless statement that closing arguments are not the evidence. And just as defense lawyers may be on the hook when the trial judge erroneously overrules an objection, so too can defense counsel be blamed when the trial judge neglects to formally rule on the objection and instead skirts the issue with platitudes and truisms. One appellate court held that because the defense lawyer did not pursue the matter and thus failed to get a ruling on his objection, he may not now pursue the matter on appeal. Of course, the appellate court did not explain how the defense lawyer would have been able to demand, in the middle of arguments and in front of the jury, that the judge do his or her job and rule on the objection. Fortunately, some jurisdictions again follow a more rational approach, finding that if there is no ruling by the trial judge, counsel should consider the objection overruled. Worse yet, even winning the battle could mean losing the war when it comes to objecting to a prosecutor's closing argument. The defense attorney's objection, even if sustained by the court, may have exactly the opposite effect from the one intended. It may call attention to the prosecutor's improper remarks and re-emphasize them in the jurors' minds. Now, this is interesting. The problem of remedies. Even in the case where everything goes right, that is, defense counsel recognizes the improper argument and quickly objects, and the judge sustains the objection, the defense lawyer's job has just begun. If trial counsel fails to move for additional relief, the action of the trial court in sustaining the objection will result in counsel obtaining all relief requested. However, a sustained objection by itself usually will not be sufficient relief. At best, it may terminate the improper argument before the jury feels its full impact, but a sustained objection does nothing more. It is not even clear how a jury would interpret the judge's ruling of sustained. Is the prosecutor's argument sustained, or is the objection sustained? And if the objection is sustained, what is the jury to think or do? Given the inadequacy of a sustained objection, defense counsel must request an appropriate remedy. Curative instructions from the judge to the jury and mistrial declarations represent the two most common remedies for improper arguments. Other possible remedies include permitting defense counsel to present a rebuttal argument or even reopening the case to permit rebuttal evidence. However, these alternatives are not generally considered by trial judges and are therefore not addressed in this article. I think we'll leave it there. We'll take it in short, small bitefuls, and so I'll find this, all this legal stuff that Michael Cicchini has written very interesting. I find his way of explaining and giving examples is absolutely brilliant. It's certainly not just heavy going all the time. Anyway, hope you're enjoying the series. Hopefully I can get Michael back on, but he wasn't able to keep talking to their walking because he had been inundated at work. But hopefully at some point in the future we will get him back and talk a little bit about some of the issues raised in that article. Anyway, catch you all again soon. Bye for now.